When someone does a legal breakdown of the whistleblower complaint against Donald Trump and goes into incredible detail, yet fails to mention the small detail that Hunter Biden, Joe Biden's son, was receiving $50,000 a month for being a board member of the energy company that was at the heart of the Ukrainian corruption scandal, I'm sorry, Legal, welcome to Political Biasville.
Population U.
Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs where I do my utmost to break down and explain things that are going on in the legal world in terms that can be understood by lawyers and non-lawyers alike, but in the most objective and politically neutral manner possible. And this is not the first time I have taken issue with the biased legal interpretations provided by Legal, although I still get a ton of useful information out of his videos. A while back, he did an interpretation of that scene from the Marvel movie Captain America or something, which I thought was fraught with bias. And I did a response video addressing what I thought to be that bias, and I'll link that video right here. This is all sort of tongue-in-cheek and not to be taken too seriously, and I do appreciate that there are certain subject matters that are just so fraught with politics that they will necessarily lend themselves to accusations of bias either by act or omission. And this is intended to be more humorous than an actual critique, but I am going to point out two fundamental flaws in Legal's video that demonstrate what I think happens to be a political bias in his view and interpretation of the law world. And yes, I'm in the car today because weekends at home, when kids are home and kids have friends who are home, let's just say it's not the quietest or most productive environment in which to get vlogging done, but I'm doing this video today, heck or high water. That's right, I said heck or high water so that this video doesn't get demonetized yet again, but it probably will because that's the way this thing doesn't matter. Now, admittedly, this is an extremely complex matter that I don't think can be done justice to, no pun intended, in one video. And all that I'm going to do in this video is read through the whistleblower complaint with my legal reflexes as an attorney in terms of the wording, in terms of the structure, and in terms of the substance. And we will get into some of the necessary context, and I will get back to the two elements that I think reveal Legal's bias in his interpretation. But by and large, incidentally, if you haven't seen Legal's video on the matter, it is 40 minutes long. It's worth a watch. Go watch it right here. And a little trick for anybody who may not know that this exists, you can actually speed up the videos to 1.5, 1.75, or 2, or in my case, you can actually slow the videos down to 0.75 or 0.5. But with all that said and done, let's get into this whistleblowing complaint, because for those of you who have been living, I don't know, I'm not going to say it anymore, but for those of you who may not know what's been going on, there was a whistleblower complaint that was recently released alleging a quid pro quo sort of corrupt bribery by Donald Trump to the Ukrainian president, suggesting that there should be a quid pro quo for $400 million in military aid to the extent that the Ukraine would reopen its investigation or look into the corruption allegations that were made against Hunter Biden, Joe Biden's son, and his involvement in a Ukrainian energy company that was known for its corruption and was at the heart of a corruption investigation back in 2016, I believe. Now, if the allegations in the whistleblower complaint are true, they are very serious and potentially very damning. And as we're going to see, that's a big if, because the whistleblower complaint is not only entirely based on hearsay, it's based on I heard hearsay, meaning that it's not even the individual relaying what was relayed to him, but rather the whistleblower is in fact relaying information that he heard was relayed to others, and I'll get into it in the actual breakdown, but at the very least, the whistleblower complaint is based on hearsay in that I heard these people told me X, Y, and Z. And the whistleblower or whoever drafted the whistleblowing complaint recognizes as much right from the get-go, and we'll get to it. I believe I can recognize attorney jargon, attorney drafting, attorney speak when I see it, and I see it all over this whistleblower complaint. If the whistleblower is not themselves an attorney, they certainly had help in drafting this whistleblower complaint, both in the structure, the way it's drafted, the allegations that are made that have certain legal implications. We'll get to it. In fact, let's just get to it right now. Dear Chairman Burr and Chairman Schiff, I am reporting an, quote, urgent concern in accordance with the procedure outlined in 50 U.S.C. 3033 K5A. This letter is unclassified when separated from the attachment. All right, what is 50 U.S.C. 3033 K5A? 50 U.S.C. Code 3033, Inspector General of the Intelligence Community. 3033K reports an employee of an element of the intelligence community, an employee assigned or detailed to an element of the intelligence community, or an employee of a contractor to the intelligence community who intends to report to Congress a complaint or information with respect to an urgent concern may report such complaint or information to the Inspector General, not later than the end of the 14 calendar day period beginning on the date of receipt from an employee of a complaint or information under subparagraph A. The Inspector General shall determine whether the complaint or information appears credible. Upon making such determination, the Inspector General shall transmit to the Director a notice of that determination together with the complaint or information. C. Upon receipt of the transmittal from the Inspector General under subparagraph B, the Director shall within 7 days of such receipt forward such transmittal to the Congressional Intelligence Committees together with any documents the Director considers appropriate. And this brings out one of the first issues with the whistleblower complaint, that being the delays within which it was submitted to the intelligence committees. Some people are considering this to be evidence of a cover-up of the act itself, and acting director of the National Intelligence, Joseph Maguire, explained that when he received the report, he did not believe that it met the criteria for an urgent matter that ought to be submitted to the intelligence committees, as required under section 30335K A, B, and C, as we just saw. There may be an issue as to whether or not the director of national intelligence has that authority, but that is the explanation on one side and the other. But let's get back to the complaint itself now. In the course of my official duties, I have received information from multiple U.S. government officials that the President of the United States is using his power of office to solicit interference from a foreign country in the 2020 U.S. election. Keywords that everyone should be picking up in this sentence. I have received information from. This is not first-hand information, this is hearsay in law. Information relayed by someone which was relayed to them by somebody else as to what that other person saw or witnessed or experienced. Hearsay is using the power of his office to solicit interference from a foreign country. This is not a fact. This is a conclusion to be drawn from a fact. Thus far, in this first opening sentence, we have hearsay and we have a conclusion but no facts from which that conclusion is drawn. And it is very important to understand when you read something, what is a fact, what is a conclusion, what is an opinion. Saying someone abused of their power is a conclusion. What did they do to abuse of their power? And let's get into that in the next sentence. The interference includes, among other things, pressuring a foreign country to investigate one of the president's main domestic political rivals. The president's personal lawyer, Mr. Rudolph Giuliani, is a central figure in this effort. Attorney General Barr appears to be involved as well. Over the past 4 months, more than a half dozen UF officials have informed me of various facts related to this effort. The information provided herein was relayed to me in the course of official interagency business. This is a self-serving cover your tushy comment. It's basically saying, I didn't get this through illegal means, I didn't get this through unlawful means, I didn't get this through spying. It was given to me in the course of my official interagency business. This sentence was not drafted that way by accident. I was not a direct witness to most of the events described. However, I found my colleagues' accounts of these events to be credible because, in almost all cases, multiple officials recounted fact patterns that were consistent with one another. In addition, a variety of information consistent with these private accounts has been reported publicly. I was not a direct witness to most of the events described. Alright, so how can you attest to the veracity, truthfulness of these statements that were relayed to you? Well, I've heard other people say the same thing and I saw it in the news. I am deeply concerned that the actions described below constitute a serious or flagrant problem, abuse, or violation of law or executive order that does not include differences of opinions concerning public policy matters consistent with the definition of an urgent concern. If this whistleblower is not an attorney or did not have an attorney drafting this, they should become a lawyer because this is pure legalese setting out the criteria that need to be established in order for this to be treated on an expedited basis in accordance with section 30335KA. It's not an accident that this whistleblower is using this specific terminology in order to force this whistleblower complaint to be dealt with in accordance with certain rules on an expedited basis. And then we get into the substance, that is to say the underlying fact pattern described in the whistleblower complaint, and let's read it right now. Early in the morning of 25 July, the president spoke by telephone with Ukrainian President Volodymyr Zelensky. I do not know which side initiated the call. This was the first publicly acknowledged call between the two leaders since a brief congratulatory call after Mr. Zelensky won the presidency on 21 April. Multiple White House officials with direct knowledge of the call informed me that after an initial exchange of pleasantries, the president used the remainder of the call to advance his personal interests. Somebody told me that they heard that the president was advancing his personal interests. Personal interests is a subjective term to qualify a fact. We don't yet know what that fact is, but we'll get into it. Somebody told me of their opinion, and this is serving as the basis of my whistleblower complaint. According to the White House officials who had direct knowledge of the call, the president pressured Mr. Zelensky to, inter alia. Inter alia is fancy talk for, among other things, initiate or continue an investigation into the activities of former Vice President Joseph Biden and his son, Hunter Biden. Assist in purportedly uncovering that allegations of Russian interference in the 2016 U.S. presidential election originated in Ukraine, with a specific request that the Ukrainian leader locate and turn over servers used by the Democratic National Committee and examined by the U.S. cybersecurity firm CrowdStrike, which initially reported that Russian hackers had penetrated the DNC's networks in 2016, and meet or speak with two people the president named explicitly as his personal envoys on these matters, Mr. Giuliani and Attorney General Barr, to whom the president referred multiple times in tandem. And this is where a lot of people are taking issue with Mr. Giuliani's involvement at all, at any level in what's going on, and understandably so. Mr. Giuliani is President Trump's personal attorney. He does not have any formal employment or position within the White House, and so a lot of people are asking why on earth Giuliani should even be involved in any of these discussions. Other people are going to say that President Trump is entitled to his personal counsel, especially given the, say, general context where everybody wants to bring him down. Those are the two positions. Decide what you may, but let's keep reading. The president also praised Ukrainian Prosecutor General Mr. Yuri Lutsenko and suggested that Mr. Zelensky might want to keep him in his position. Note, starting in March 2019, Mr. Lutsenko made a series of public allegations, many of which he later walked back, about the Biden family's activities in Ukraine, Ukrainian officials' purported involvement in the 2016 U.S. election, and the activities of the U.S. Embassy in Kiev. See Part 4 for additional context. And so in this whistleblower complaint, you have hearsay allegations to the effect that the president is corrupt and using his position in office to advance his personal interests, all the while including side notes that exonerate Joe Biden and Hunter Biden from the allegations of corruption. Corruption involving an energy firm that was paying Hunter Biden $50,000 a month to sit on the board of directors. The White House officials who told me this information were deeply disturbed by what had transpired in the phone call. And this is where I think we've sort of gone past traditional hearsay. Right now, we're not just saying someone told me this. This whistleblower is saying someone told me this, and now the whistleblower is saying how the other person felt. The whistleblower is commenting on the sentiment of the individual who relayed to them information that they are relaying now in the context of this whistleblower complaint. Depending on which side of the political spectrum you are, you will either take this as gospel or you will take it with a grain of salt. But it is nonetheless hearsay, and hearsay relaying of what the perception of the other person's emotions and state of mind were. In law, it is what it is. All right, and moving on in the complaint, we get into another very important fact, which was apparent efforts to restrict access to the transcript, notes, or text of the phone conversation between Trump and Zelensky, and let's get into it. Based on my understanding, there were approximately a dozen White House officials who listened to the call, a mixture of policy officials and duty officers in the White House Situation Room, as is customary. The officials I spoke with told me that the participation in the call had not been restricted in advance because everyone expected it would be a, quote, routine call with a foreign leader. I do not know whether anyone was physically present with the president during the call. Efforts to restrict access to records related to the call. In the days following the call, I learned from multiple U.S. officials that senior White House officials had intervened a, quote, lockdown, end quote. All records of the phone call, especially the official word-for-word transcript of the call that was produced, as is customary by the White House Situation Room. This set of actions underscored to me that White House officials understood the gravity of what had transpired in the call. And this is where we go to Legal Eagle's analysis, which reeks of bias for the following reasons, and let me just play you a clip from his video.
This is bad. I don't see a other side to this. This is on par, if not worse, than what was uncovered in the 1974 Watergate scandal. I don't see a second side to this.
I've said it before and I'll say it again. When someone says, I don't even understand how you can believe what you can believe, that is a reflection on the person saying that, not a reflection on the validity of the arguments of the other person. So when Legal Eagle says he doesn't even see another side to this, how it can possibly be justified, that, I respectfully submit, is evidence of Legal Eagle's bias and partisan view of the situation. Agree or disagree with the justification. This is in fact the justification that some people are giving for why this particular call may have been put on some form of lockdown or restricted access. The president has had now 3 phone conversations leaked to the media. Agree or disagree with the justification, some people are suggesting that the reason why phone conversations may have been placed on some sort of extra lockdown was specifically to prevent them from being leaked to the media, as had occurred 2 times in the past prior to this one. Now, I don't know if that is in fact unlawful or illegal, but one cannot just pretend to ignore the justification for why this might have been done. White House officials told me that they were directed by White House lawyers to remove the electronic transcript from the computer system in which such transcripts are typically stored for coordination, finalization, and distributed to cabinet-level officials. Oh, and on multiple occasions leaked to the press. Instead, the transcript was loaded into a separate electronic system that is otherwise used to store and handle classified information of an especially sensitive nature. One White House official described this act as an abuse of the electronic system because the call did not contain anything remotely sensitive from a national security perspective. One White House official described this act, hearsay, as an abuse of this electronic system, opinion, because the call did not contain anything remotely sensitive from a national security perspective. Yet another opinion. So here we have hearsay of the opinion of somebody else. Take it for what it's worth, and if it can be proven, it may in fact be a problem. But the problem with these types of allegations is that they're difficult to prove even by direct evidence. That someone thinks it was an abuse because it didn't contain any sensitive information, that is an emotion based on an assessment, and how do you go about disproving that? You're going to get an opinion on what is sensitive information and what is not, and you're going to have diverging opinions on whether or not it was abusive. Whether or not it was illegal is a matter of fact. Was it in fact illegal or unlawful to do what was done? But thus far, this whistleblower complaint is based on hearsay evidence from someone who thought it was an abuse because they didn't think that there was anything remotely sensitive in the conversation. Section 4 of the whistleblower complaint describes the circumstances leading up to the July 25th phone conversation between Trump and Zelensky. And one of the more important allegations that was included in the article by The Hill is the last bullet, and reads as follows: that former Vice President Biden had pressured former Ukrainian President Petro Poroshenko in 2016 to fire then Ukrainian prosecutor Prosecutor General Viktor Shokin in order to quash a purported criminal probe into Burisma Holdings, a Ukrainian energy company on whose board the former vice president's son Hunter sat, and for which he was paid $50,000 a month. In several public comments, Mr. Lutsenko also stated that he wished to communicate directly with Attorney General Barr on these matters. Further down, the whistleblower complaint alleges as follows. On May 9th, the New York Times reported that Mr. Giuliani planned to travel to Ukraine to press the Ukrainian government to pursue investigations that would help the president in his 2020 re-election bid. That itself is a subjective opinion, conclusion, interpretation of what Mr. Giuliani did. It may or may not be accurate, but it is nonetheless a subjective qualification. It is not itself a statement of fact. In his multitude of public statements leading up to and in the wake of the publication of this article, Mr. Giuliani confirmed that he was focused on encouraging Ukrainian authorities to pursue investigations into alleged Ukrainian interference in the 2016 US election and alleged wrongdoing by the Biden family. That is more of a fact. That is in fact what Giuliani did. Some people might consider that to be the pursuit of justice, and there's nothing wrong with it. Others might consider it to be, Hello? Yeah, I need to come in?
Well, do you think you could take Ethan for a
little drive?
drive?
Yeah, okay, give me 5 minutes.
Okay.
Goodbye. All right, we have to go fast here because my time is up. Some might consider that to be an actual legitimate pursuit of justice, while others might qualify that as helping Trump get reelected in 2020. But those are both opinions based on the fact. The mere fact is what is important. That is itself the fact. The spin, leave the spin to the pundits. I don't think spin should be in a whistleblower complaint. On 13 June, the president told ABC's George Stephanopoulos that he would accept damaging information of his political rivals from a foreign government. On June 21st, Mr. Giuliani tweeted, "New Preds of Ukraine still silent on investigation of Ukrainian interference in 2016 and alleged Biden bribery of Poroshenko. Time for leadership and investigate both if you want to purge how Ukraine was abused by Hillary and Clinton people. In mid-July, I learned of a sudden change of policy with respect to U.S. assistance for Ukraine. See enclosure for additional detail." All right, and this is where we actually get to the crux of all of this. The allegation is to the effect that Trump was strongly suggesting or engaging in an actual quid pro quo to the effect that if Ukraine wants this $400 million in military aid, they would reopen the investigation into Biden and his son. And to that end, the $350 or $400 million in military aid that was promised to the Ukraine was withheld from the Ukraine up until September 11th, I believe, when it was finally released to them. And the basis of the impeachment inquiry based on this whistleblower complaint into the president is that Trump used his position of power to suggest we're going to withhold this $350, $400 million in military aid, but we would really like you to look into Joe Biden. And then when he got some sort of assurance, for lack of a better word, or indication that the Ukrainian president would look into this type of corruption, the military aid was then released to the Ukraine. Now, incidentally, a parenthesis on the military aid, it's in fact more of a subsidy in that the US gives $350, $400 million that is earmarked as military aid to the Ukraine, only so that the Ukraine can then in turn turn back and buy weaponry from the United States. So it's basically a total wash. $400 million goes to the Ukraine for aid, and then the Ukraine uses that money to buy weapons from the US. It's great. It's a wash with taxpayer dollars, but that's just my opinion. And so that's it. That is the bombshell. This whistleblower says that there was this conversation wherein Trump said, "Congratulations on becoming president. We look forward to a long-lasting relationship with your country. What's going on with this? And, I'd love for you to look into these corruption issues. In the interim, military aid is withheld, but finally released to them in September." And people are viewing this as an abuse of power, quid pro quo, extortion, bribery, whatever you want to call it. And others are saying this is not a quid pro quo, this is not extortion, this is not bribery. This was just a conversation between two presidential leaders, and that the money was not withheld as a quid pro quo because ultimately there was no reinvestigation into Biden or his son, and the monies were released, that the monies were withheld pending an investigation into the corruption in the Ukraine so that the US could be sure that the $400 million that they're going to give to the Ukraine is not going to go to corrupt purposes. So that is a breakdown of the whistleblower complaint, and I hope it gives you some additional insight into the complaint and the situation at large. I hope I did it justice because I am well aware of the fact that I too can be accused of partisan interpretation by act or omission, and I do my best to present both sides of the story, and I hope I did that. And if you like this content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below if you want some merch. I don't think you can see it. I'll post a link to this and pin it in the comment section below. And if I don't go get my kid, I may have plenty of time to vlog, if you know what I mean. All right, and now you know you vlog. Peace out. Booyah!